Hi everyone, welcome into Life and Law with Debora Diaz. I'm Barbara Marville. Thanks for joining us.
Wow. I'm Debora Diaz.
We have a great show coming up as always. It's like an overlapping show, Debora, from last week to this week.
Yes.
And I'm going to let you take off because we have a lot to cover this time as well.
Okay, well, last week, if you remember, if you were with us, we started the 25 things not to do while going through a divorce.
Exactly.
And the first 8 we got through, which I'm just going to go quickly recap. Don't lie or hide things from your attorney. Don't use illegal drugs, and don't associate with people who use illegal drugs. So this is 25 things not to do while your divorce is pending. And while a lot of it's very applicable to other litigation pending. Number 3, don't discuss the case with your children. It's inappropriate, it should not be done. Don't post your divorce drama on social media. We'll keep emphasizing that. I'll bring that up on later points. Again, don't post your divorce drama on any social media. There's absolutely no expectation of privacy, and it can be used in a court of law. Don't bring your new significant other around the children prior to the divorce, if at all possible. Delay it if you can. Early on in the case, don't fail to take an inventory of your household items so you know what's at what you have while memories are fresh, while the divorce might just be starting, and you know if things are missing. Don't fail to keep a divorce calendar, I call it. Give my clients a calendar and to be logging in and writing down activities so that you have it down the road. When your memory's faded, you have something to refer to. And we covered don't bring your new boyfriend or girlfriend to court or to mediation. It's inappropriate, and again, it inflames emotions. So those were the first 8 that we went through.
That's just to get started.
That's just to get started.
Plenty
again,
more.
Do not do's. Number 9, don't leave nasty voicemail messages. Again, there's no expectation of privacy. If you call up your significant other, they're not there, you want to leave a message, don't start with threats. You leave an appropriate message. I'll call you back or call me back. Don't start any threats. Don't be calling any names. Again, it's inappropriate. No expectation of privacy, and it can and will be used against you down the road in your case.
And you would think that would be common sense, but
well, a lot of things we think.
But in the heat of emotion.
In the heat of emotion, you might be feeling really bad that day and leave a message, and you think that you've got to put your frustration out in the message. So we're saying don't do that. But of course, keep any messages that might be left for you, because again, on the reverse, that could be used too. Excuse me. Don't dispose of assets to be vindictive to your spouse. Okay, and whether we talked a little bit about that or not, there is, once a case is filed, a temporary order is put into place, meaning don't be moving around assets, don't be selling your husband's favorite gun collection, don't be selling your wife's Yadros and getting rid of jewelry. You're going to have to justify it to the court. So this is, things done, don't be vindictive. Okay, you have an obligation to keep assets as they are, and if there's spending of assets, you are going to have to justify that to the court. Remember to keep track of everything that you're given in your case regarding orders that come forward. You should know what they are. You should read them. If you don't understand something that you receive from your attorney, call, email. Ask the questions.
Right.
All right.
Communicate.
Don't make assumptions. Communicate. Make sure you understand anything that's any order that's put into place. Okay. If there's a misconception, you don't understand exactly when child support's due, when you're supposed to pick up, or any time sharing, anything you don't understand, it's better to ask questions and not to make an assumption. So.
That's right, because you know how we get in trouble by assuming.
Yes. Yeah. Don't fail to keep your attorney informed where you are, wherever you may be. You move, your phone's changed, you may be going out of town for a specific period of time. Sometimes things happen very quickly in a case. Your attorney needs to get a hold of you, so your attorney should always be able to get a hold of you and everything. And it's pretty easy to leave an email address or leave a telephone number. Okay, you want to be be able to be reached regarding your case. Related to, again, about the temporary order that goes into place about infringing on assets and moving assets is don't start charging up things. Don't start opening up credit in your spouse's name. And as an aside of that, I'll say, that's not allowed. That's not allowed. We had, several years ago, I had a case where, and I always have my clients run a credit report. You run a credit report at the beginning of the case, run a credit report at the end of the case. You know what's going on out there. Sometimes, especially in this day and age where, there's this free sharing of information and there's people have access and you can open up accounts. And what happened is we went to final hearing and one of the spouses had opened up about $30,000 in credit card debt, had taken cash withdrawals after there was a mediation agreement. So there was a mediation agreement in place. Everything was set as far as what was going to happen with all the assets. And then get to final hearing, run a credit report previous, and the other spouse had run up credit. And that's a big no-no.
Wow,
Okay?
I would guess so.
Okay, yes.
So how'd you handle that?
That had to be, guess what? There was no final hearing that day.
I would guess not.
The parties were going to go back to resolve that issue of getting the credit, making sure that the other person that had not run up the credit was not responsible for it.
Oh, see?
What happened? Because
You think there was kind of
that was done.
The wrong thoughts there for the intention?
There was an intention that this person was being deceptive, was getting a credit in the other spouse's name, and thinking that then the spouse was going to be liable after the divorce.
Oh, that's sneaky.
So
that's sneaky stuff.
Yeah, that's not good. Okay, that's not good, and it didn't look good in front of the court either. Yeah.
That's pretty good information. See why you want to watch us?
Yes. Okay. This is related. It's, don't make large purchases when you're going through a divorce. This isn't the time to go out and buy a new car. It's not the time to be spending a lot of money on, new 60-inch TV that costs several $1,000s or something. You're going to be, remember, you're going into, and I say this and it may, be repetitious, but it's always going to cost, more for one person to live than it is, a two-income household or two people. So there is going to be a cut in the family income. You need to be mindful of what you're spending money on.
And especially when it's a family and you have children.
Exactly.
So it's those babies.
So think about that. It's not the time. And again, this is I can't make this stuff up. This is real stuff. Okay.
Exactly.
I had one client. We're going through a divorce, and sadly, this was my client. This was many years ago. Going through a divorce, and we're trying to. She's saying she can't afford this. She can't pay. She needs money to live on. I'm at her attorney trying to get temporary support in place. And my client goes out and gets a $10,000 facelift.
Oh.
Without my knowledge. Okay? So now that doesn't look too good. How does that look when I'm trying to argue on the other side?
Well, she looked good. I guess
she thought she did.
But that's not the thing to do.
That was not the thing to do as far as making. It's hard to justify. It's hard to justify, especially when we're making the argument. She has no income, and she didn't on paper, and she can't. So we need temporary support. And she goes and spends that kind of money on.
So how would you find out with something like that?
What happened is, what happens is because apparently there was some testing that was required that was covered by insurance, but the facelift itself wasn't because it's cosmetic apparently.
Right.
So she's still on her husband's insurance. Husband gets the information.
Oh, wow.
The billing comes.
Wow. So, of course, she had to look different too.
No.
Oh, really?
I don't think she did.
So it wasn't such a.
I don't know.
So it wasn't such a good decision.
Well, no, I just, I'm not going to make, say that. I'm just saying it's something that was inappropriate. I'm not saying inappropriate to do, inappropriate to do while you're in litigation, saying that you don't have any money.
Exactly.
Okay.
It's misleading.
It was misleading.
Disingenuous.
It was, and I was blindsided, and I had no idea. So that comes back to reiterate my point is that about disclosing everything.
I was going to say, it goes back to like, stay in touch, communicate with your attorney, right?
Yeah, and she was, in the small bit of in her defense, she was just feeling like she just needed it to feel better. That was what she said.
Okay.
So, I'm not, she's going, there's a lot of different emotions that go on in a divorce. So,
but that's, you just blow me away with all these stories.
I said, I can't make it up.
I know you can't. So we have a break coming up, and I know you have a lot of new things to cover here. How much time do we have there, Dylan? Could you say a minute? 30 seconds.
30 seconds.
So
okay.
I need to take some deep breathing here after all of that during that 30 seconds. And when we come back.
Don't forget our email address, lifeandlawwithDebora@gmail.com.
That's right.
And we'd love to see your questions.
Mm-hmm. And they sort of overlap because we're getting so many questions to cover, so many, real stories.
Repetition. There's, real things. People have questions, and I try to answer them.
That's right. So stay with us. We have more things coming up in the next of the hour, so stay there. We'll be right back.
Thank you.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi, everyone. Welcome into Life and Law with Debora Diaz. Well, we are into our second segment, and the first one was packed full of some powerful information, things that we would never really think of on our own. Whether you're going through a divorce, maybe you're thinking of it, or maybe you have friends or relatives that are. Tell everyone you know to tune in on Thursdays at 4:30 for Debora's Law Show, because I'll tell you, I am learning so much. I look so forward to working with Debora because she has over 22 years of experience in family law. So you're coming to the right place at the right time. Let's get into the next, because I know your list is growing and growing.
Again, the list is it's 25 things not to do during a divorce, and very applicable other family law litigation, and can be applicable to other cases, but it's things not to do, and some of them are applicable to other areas. Number 16, don't keep your children from your spouse. You have children together. I tell my clients, you're divorcing each other, you're not divorcing the children.
That's true. That's
So
very true.
it is, yes, you might not like what the other side's doing, what the other parent's doing, but as long as we don't have any safety issues, this is a different thing, safety of the children, the other parent needs and wants to see the children.
Debora, do you find that a lot? Does it happen a lot?
It does happen a lot. It's a retaliation. Sometimes if they don't feel as though that they're getting enough money, or the case is pending, and they just think, well, I'm not going to let him see the children, I'm not going to let her see the children. It's on both sides, and that's not the way to handle it. It will be addressed down the road, and it won't look good in the court. If we come to litigation where the judge is the one that's going to have to make the determination on who is the majority caretaker, timesharer, it will be an important factor. How cooperative were the parents? How cooperative? How were they able to get along? Were they able to get along with the time sharing schedule and be flexible? And you don't withhold your children in retaliation. The children need to see both parents.
So basically, what you're doing during that time before final judgment, you're sort of setting the tone for the future?
It's setting the tone for the future. It is setting the tone for the future, and it's going to be precedent when you go into a trial as far as what happened. All of that will be evidence that could be admitted into the trial, if it is a trial. Okay, that the judge will weigh as far as, it's all credibility. Okay, so you don't, I know feelings are hard, and it's a difficult where the feelings are inflamed, but if there's concerns about safety, if there's concerns because the other parent is disparaging, talk to your attorney. Okay, we can address it. Okay, we can make it, there shouldn't be disparaging remarks, and there should be time sharing. Okay, again, this is in mind when we're talking when there's no drug issues, no alcohol abuse, and the children are safe. You don't have those concerns that are legitimate concerns, then the children should be time shared with both parents.
On that note, do you extract that information from the get-go when you meet with these couples? Supposing there is no drug issues, in the beginning, or alcohol, or any kind of abuse, and maybe it kind of happens after things start rolling. I mean, I would think that could be quite a challenge too. And how do we know these things?
You can't know unless you ask, or if something happens, if there's something that's gone on, that some reason, maybe there's, I've had cases before where maybe one of the parents, while the case is pending, gets a DUI,
right?
And that's going to be right away. That's out there, and it comes, the knowledge becomes available. So,
Sure.
But asking the questions, and if you don't. Again, sometimes if it is a violation, I've had them where there's a case pending and one of the parents is overdosed. Things. So.
Sad.
Yes, it's sad.
Really sad. Okay.
Okay. And this is a biggie. I'm going to say this. I come to this, and I've had an explosion in this area in the past couple of years. And I'll go into those, but. Don't get anyone pregnant. And for the guy, and don't get pregnant with someone else's child while you're still married. And that happens. That happens.
It sure does happen.
And it's going to delay the case, and there's a lot of other issues. For example, legitimacy, and a legitimacy is when a child is born during a marriage, they're presumed legitimate. We have this, public policy, a child is legitimate born during the marriage. So
Sure.
if husband and wife married, husband and wife gets pregnant by someone else, and the child is born during that marriage, husband is presumed to be the father, even though he may not be bio father. So we'll call him bio father and
Okay.
legal father. So we
Okay.
have different terms.
Right.
Okay, so that's the additional layer on. And so legal father is going to have to pay child support because he's the legal father.
Right.
Until there's some kind of determination of paternity or parentage happens. So it adds an additional layer onto the case, okay? As I said, I can't make this up. Within the last couple years, I've had 2 different cases where the women have come to me and they have been pregnant by someone else. And so the need was quickly to get divorced, to get the divorce in place before the child was born. So we didn't have to go and try to untangle the relationship of, between bio dad and legal dad. Okay, that's why I'm differentiating between the terms.
Wow. You give a lot.
This is stuff that I told you I cannot make this stuff up.
Yeah,
okay?
well, it happens, and so this is really good information to know.
Yeah, so really, I know things happen, but if at all possible, this is the thing of that really some good foresight and some planning about not, because it really becomes a legal quagmire of a mess trying to untangle. We've had, again, because the court, a child born during a marriage, the court is not going to delegitimize that and say, no, legal father, you're not the father. Okay. Because
Wow.
we have this presumption that we want to have,
Yes.
children born during a marriage to be legitimate.
Yes, and this is a lifelong drama.
Yes.
It becomes a lifelong drama.
Yes, not
So-
later on, you might be able to get some voluntary things, and there's cases, there are all kinds of, litigation where and then later on, dad finds out he's not the real father. Sometimes the stuff comes out and sometimes it doesn't. Maybe it doesn't come out until later on when there's a paternity test for some reason. And then, so you're going to have the litigation between bio dad and legal dad and bio mom.
Wow.
And I'm saying bio, and I'm using that as biological.
Right.
I'm trying to keep it so it's not too confusing.
No, you're explaining it pretty
Okay,
well.
all right.
I get it. In
Okay,
other words,
so-
like,
Yeah.
be cool. Don't get pregnant or don't
And
get somebody else pregnant.
Exactly. I mean, and it happens too where I've had conversations where, male comes in and he's got someone pregnant, he's still married. So the ramification is that child is going to be born illegitimate. Okay?
Yeah.
Because he's still
Yeah.
married. So
There's no way getting around that.
There's no way getting
It
around
is what
that
it is.
because- Yes.
And then that child faces that for the rest of
Yes.
their life if they find out,
There's
which,
a lot of legal issues involved. If this is what's going on, you need to seek legal counsel.
yeah.
Okay.
And keep your
Okay.
attorney informed.
Yes, and then again, probably, the best thing is don't do it, but. Okay, we're up to number 18. Don't lose your temper or show anger at mediation.
that's a good one.
Right.
Yeah.
At mediation
Yeah.
or in the courtroom. At mediation, you're there. Yes, it's highly emotional, but you're trying to get an agreement. So try to, be as calm as possible and not be angry. The anger will not help to get an agreement.
I would guess not.
It's not going to. You're going to inflame emotions and most likely lead to not getting an agreement.
Yes,
Okay?
yes.
The same way as in court, if you're in trial or at a hearing, don't show your anger. You need to be poker face. You can't get angry at the other side. A lot of times, you want to say, she's lying, he's lying. And
Especially if they
interrupt.
are.
The court will not like that. The judge will not tolerate that, will not like it, and also it goes to this credibility issue, how you handle yourself. And think about it this way. You're going, so let's say we have an issue of the time sharing and, you know, who's the better parent to have more time and that kind of issue. And then you have really an angry outburst in trial or at the hearing, okay? The judge is going to know that. The judge is going to remember that. Okay, what is this, this anger about?
And if there's children.
Involved, it's to stay as calm as possible.
Makes sense.
And your attorney should be preparing you for that, to be calm and everything. I bring, when we're in either depositions or hearing or mediation, I give my clients a pad, a pen. You want to say something, you want to write it down. Write it down. Okay, and we can address it. But no outbursts.
There you go.
It doesn't look good. Number 19. It's don't listen to your friends, your neighbors, the nail technician, your hairstylist, and the whole other list of people that are going to have an opinion as to what you should get, should be doing, or shouldn't get, or should be doing during your divorce. If you've paid an attorney and you have an attorney that's representing you, that's what your attorney's for.
That's right.
To give you the advice.
Legal
advice.
Not opinions.
Not opinions.
Yeah.
And I say this because everyone's case is different.
Of course.
And they say, people will talk back and forth. I got alimony, and I got this much alimony. I got this much child support, and I this. Okay. Incomes vary. The case varies. So everything's fact specific. You're telling your case to your attorney, and so you need to listen to that advice and not your other people around you. Okay, these third-party interferers, okay, can be your support system in that they're calming you, but they shouldn't be feeding you information.
No, because that just triggers more emotions and everything. Exactly. So hang on with that thought, and we'll be right back after this.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi, everyone. Welcome back into Life and Law with Debora Diaz. We're going to get right into our next questions here.
When we ended on before the break, I was finishing up and saying, don't listen to your friends and stylists and that whole, what I call third-party interferers.
Sure.
All right. And bottom line is, if you don't trust your attorney's legal advice, then you need to change.
Yeah.
Okay. You're paying someone for legal advice, to get you through the legal process. That is who you need to be listening to.
Do you think that might be why people consult with their friends, because maybe they're unsure with their attorney?
It could be, but sometimes these are people, they're just volunteering the information.
True,
they're just coming in,
they know
want to tell
more.
you their case.
They know more than the attorney.
They want to tell the case.
Yeah.
And this is and related to this is, and I keep saying this and it's going to be repetitious, don't confuse your Google search with my law degree.
Thank you. Thank you for saying that.
Friends and all your friends, okay? You find out everything that you read on the internet is not true, okay? So, and there's also variations and nuances, and the law is there's so many nuances.
Right.
So a case is fact specific.
Well, the law is the law.
Yes, but the law is the law, but there's also many interpretations, and it's fact specific.
Right.
And so that's why your best is, and it really does, if you don't trust your attorney, then go. You can at least have a consultation with someone else.
Of course.
Go and see. You have to have that good. You really do have to appreciate and be trusting your attorney's advice.
Yes.
And if you don't, then you do need to look elsewhere.
Of course. Of course.
If you're not confident in that. Okay.
That's right.
Okay. Let's see. Number 20. Don't fail to consider the tax consequences of a divorce. And this can be done ahead of time. You're talking to your tax planner, and knowing as you're thinking about how assets are going to be divided, to get some advice that what tax bracket you're going to be in. So it's some initial information out there as you're preparing for the division of assets. And it's going to come up in your case. This is just in the beginning saying this. I mean, this is something I talk with my clients to tell, working with their CPA or financial planner to look and see what tax consequences may be happening. So that's part of the process. Don't fail to update legal documents, such as a power of attorney. If we have, a husband and wife, they're going through a divorce. I had a situation a couple years ago, and wife needed major surgery. Husband's her power of attorney. Well, she needs to make sure to change that. She doesn't want the husband making the decisions about what happens in anything in their legal affairs and things like that. So when we're talking that we have assets and children involved, you should change your power of attorney. Make sure that you're naming someone else instead of your spouse as the case is pending. This is particularly true when some cases can go on for a lengthy period of time.
That's right.
Okay, so you do want to change that. Don't fail to review your beneficiaries on retirement accounts, bank accounts, insurance policies, a whole list of things as the divorce is progressing, and then at the end of the divorce is to make sure that you're looking at changing. Like in some retirement things, you're not going to be able to change things as the case is, but in other things you are. I mean, if you have a large lump sum of money in your a lump sum in your bank account and you don't want your spouse to get it, then change it.
There you go.
Change the name, the payable on death person on the account, or however it is that they're doing the planning. So it's
Good
it's
advice.
looking at everything that's going on in your case. I always tell my clients don't fail to understand that the final judgment is not the end of the divorce when you have children.
Oh, yes. We've talked about
To
that.
understand
Yeah.
that you are still co-parenting on through school activities, through graduations, through marriage, through showers, through marriages, whatever. You're still, it's not the
Yeah.
end. It's not the end.
Yeah, it's not like you're really ever, I mean, you're divorced, but you're not in a sense.
You're divorced, but you still can have, I mean, I keep emphasizing you still have to co-parent.
Yeah, always.
And it doesn't mean you're not best friend, doesn't mean you're going to have to be best friends, but you can be cordial, you can at least talk.
Yeah.
It's for the benefit of the children.
Right.
The more the parents can can get along and talk, the healthier, the better off the children are going
Oh,
to be.
there is absolutely no doubt about
Okay,
that.
we get
at
into,
all.
as the children are growing up and they get into their teen years, we know this, they play off one parent against the other with this. And then we start hearing, I'm going to go live with dad, or I want to live with mom, and that kind of thing.
Yeah.
And why do they want And why do they want to do that? Because they think the grass is greener, or because, one parent's going to be less lenient, or, more lenient, whatever, for that whole thing. So
Exactly, or they're going to get...
They have to be united on this. The parents have to be united.
If they want it to be successful.
If they want to be successful. That is. And there's a lot of good parenting classes out there, good books on this subject.
I'm glad that you mentioned that. I'm glad you mentioned
there
that,
are.
because if there's one or the other parent that needs some counseling, just know that it's out there,
There
because
is,
it's for
and
the
there's
good of
plenty-
your
there's
children.
Some good books on co-parenting. There's some good sites to get some information on. So
That's right, especially if one or the other or both of the parents are going
Yes.
through a lot of
yes.
anger
I know
stuff.
it's hard.
Yeah,
But you
yeah.
have to keep thinking that is the best for the children.
That's right.
I'm always telling my clients to don't fail to think of the ramifications. I just posted this the other day on one of my Facebook pages. My business is to think before you speak.
Oh, yeah.
Think, is it the truth? Is it going to serve a purpose?
Yeah, yeah. Because once you speak, it's already said.
As I say, you can't unring the bell. I was having this conversation with someone last night. Once something comes out of that mouth that's mean, that's spiteful, that's angry, you can say you're sorry, but you can't unring the bell.
No, I've never heard it said like that, quite like that. You unring the bell, but it's true. It's really true. Once it's said, it's said. You can't take it back.
Yeah.
And you're giving birth to
And
that through words.
Through words, yeah.
Yeah.
Yeah. And don't be your own lawyer.
Really?
My 25th one. Do not be
Oh, you
your
mean
own
you have to go to law school
Yes.
for all that?
Because, over the years, I've seen so many agreements and mistakes made of people that they agree to something that they either didn't read or they didn't understand, and then they are in my office and they are saying, I didn't realize, the pension was divided this way, and you mean I'm not going to get this, this, and this, or I didn't realize that's how child support was calculated. I didn't realize if I signed off on this, I wasn't going to get any of this asset, or things, all kinds of, so many different scenarios, and usually the person on the other side is near tears or crying or very distraught because they didn't realize this agreement that they tried to do on their own, or so it's even if an attorney you don't have an attorney throughout your case, it's well worth having a consultation. There's what's allowed now in Florida is what's called the unbundling of legal services. So an attorney can be in a case or represent for a limited period of time.
Really?
You could have you could retain your attorney and just say, go to mediation with me. As long as the client and the attorney, and it's that they're in agreement as to what the representation is. It's called limited representation.
Okay,
So you can get, you can hire someone just to review your agreement. So there's many possibilities. There's resources out there. You could go in and just have, a consultation. You can get a second opinion on something. So when assets are involved and when children are involved, it's well worth it getting legal advice.
Yes.
Instead of trying to do it on your own.
Absolutely. I didn't know that. I like that. Now, does that affect the fee schedule as well?
It's going to be less, and that what we call this unbundled legal services, meaning, as I said, an attorney can just represent for mediation. You might just have an attorney retain an attorney for a hearing, a certain portion of time, and then that's it. As long as the client understands they're only being represented for whatever that limited representation is, it's allowed.
And depending on what their situation is, because like we've said before, everybody's circumstance is different. Well, that's a whole lot different than cable bundling. Try to unbundle that.
That's a
good luck, right? So this is good news to have.
Yes.
We're going to take a break, and when we come back, we're going to cover some more great things with Debora. Isn't this wonderful? Very educational. Really gets you thinking in your noodle.
That's what we hope.
We'll see you right back.
Revolutionary in his field, Dr. Bonatti created, perfected, and patented the Bonatti spine procedures. Using his genius, Bonatti invented precise tools necessary to minimize surgery, scarring, anesthesia, and recovery. So successful are the Bonatti spine procedures, they consistently reflect 98.75% patient satisfaction. 50,000 successful procedures have been performed exclusively at our location. Over half our patients have suffered from failed back and neck surgeries at other facilities. Bonatti succeeds where others fail.
Hi, everyone. Welcome into Life and Law with Debora Diaz. I'm Barbara Marville Kelly. Thanks for joining us. A lot of discoveries here in this show today. As always, we recapped a little bit from last show last week, but you still have a few new tidbits that you want to share with us in your odds and ends in the last segment.
Yes, we'll do that after. Yeah, our odds and ends. So finishing up, just to take that, don't be your own lawyer, my final top 25 not to do's, is getting back to the point that to drive home that many times it's more expensive, both emotionally and costly, and the ramifications by not consulting before you enter into a settlement agreement.
Yes.
So that's my point on don't be your own lawyer.
Right.
So especially when there's children and property involved, because there's many ramifications for that. So that finishes up my 25. You can go to my website at www.deboradiazlaw.com and review these 25 things not to do if you would like.
And that's really good because it's easy to forget. I mean, to retain all of this, because we never know who's out there as far as being in a particular situation. So always check out Debora's website. Tune into the show Thursdays at 4:30. Now, we still have plenty to cover.
Yes, we have questions.
Yes, we do.
So
So I live in Florida and my spouse lives out of state. I want a divorce. Can I file for divorce in Florida even though my wife has never lived in Florida?
And that answer is yes.
All right.
A person may.
Yes.
And because, again, as long as one party has resided in Florida for 6 months prior to when the petition is filed, the divorce can be filed. So husband lives here. If he's lived here 6 months, he can file for the petition for divorce.
Okay, as long as they're here 6 months.
As long as the party filing, who's ever filing, has been here 6 months.
Okay, so it's not like you can
you can't
come down
move
here.
This is to prevent this forum shopping and you go from state to state to look where might be the best state for your divorce. It's,
Really?
part of it.
Yeah.
But, the courts don't want to take cases that they don't have jurisdiction over.
Sure.
Okay, and so
Sure.
the jurisdictional requirement for the state of Florida is 6 months residency prior
know.
thing. So that's why always at every final hearing, we ask that the client bring a copy of their driver's license so that it can be shown to the court that the petition was filed within the appropriate time.
Okay,
That the person had been in Florida 6 months prior to the petition.
so it's not like 4 months, but by the time the
No.
divorce is final, it's 6 months. It's 6 months prior.
Prior.
Okay, very good.
Yes.
Okay, I have been putting money into my retirement account and have a pension at my job. Is my husband entitled to any of that money?
Yes.
That would be a yes.
Yeah, that would be a yes. That goes back to the portion, whatever the date, they got parties married in 2016. One party's contributing to the pension. The employed spouse, it's marital. We come from, date of marriage is like this magical date. Can be magical, cannot be magical sometimes.
Right.
But this timeline of the date of the marriage is when the clock starts ticking as far as marital assets.
Okay.
Let's view it that way, that you have marital assets. Now, as an aside to take that question further, if the person had been employed prior to the marriage at the same employer that he or she is accumulating the pension, that time before the date of the marriage is premarital.
Oh, okay.
That's not marital. That's not subject to the division.
Okay.
All right? But whatever that time period is, that's going to have to be valued. Like if the person 10 years had worked 10 years prior, then gets married, and there's only 1 year in the marriage and pension, the wife's or other spouses, whoever it is, portion of that is very minimal.
That's right. Makes sense.
So it's really tied to this. It is tied to the date of the marriage.
Okay. Thank you. How is child support determined if one party does not have a job?
That's such an open question. Well,
Yeah.
okay.
Wow.
Well, we have to look at the reasons. Why isn't the other person employed? Right? The court's gonna look at that. There's got to be some. If the person's employable, what's the realistic salary that they could make? They're going to be at least what's called imputed, meaning given credit that they could make at least minimum wage. All right. If the person has skills that are verifiable. Maybe prior they worked as a teacher or a nurse, and now they're just not working. Why? Are they ill? They can't work. They can't get a job. You're going to be imputed with at least minimum wage, and it could be more required to get a job. They've got to work. So they'll at least be imputed with minimum wage, and then maybe with litigation and whatever's going on in the case, whatever the attorneys are doing, we'll be saying this person needs to go out and get employed, because we can say they're going to be at least imputed minimum wage. But it has happened, and it can happen if we see voluntary unemployment or voluntary underemployment. And by underemployment, I mean someone is trained as a nurse, and we know nurses can get jobs in the state of Florida, okay?
Yeah.
And they're not working right now. Why aren't they working? Is it health-wise or not? Because the court very well could impute whatever a nurse makes. I don't know what that's right off the top of my head right now, but let's say it's $20 an hour. The court has the ability and authority to impute $20 an hour to that person.
Even though they're not working.
Even though they're not working. Now,
Wow, I didn't know that.
You have the ability to make this. You need to go out. Again, it's verifiable. Can the person? It's not going to happen. Many cases, sometimes when somebody hasn't worked for 10 years.
Sure.
And then they're going and saying, well, you need to impute, this amount of money to this person. Well, it has to be verifiable, shown in the community, what's the work, that person really could be employed at that wage. But at a minimum, it's going to be minimum wage. If the person is employable, healthy, able to get a job, you're going to get, minimum wage for so many hours,
Sure.
30, 40 hours a week.
Wow.
And then the calculations would be done.
Right.
Okay.
Good to know. Thank you. My former husband is not spending time with our children. He cancels his time on a regular basis. My children are disappointed. Will a court modify the time sharing order?
Very possibly. Very possibly that could happen. The child support is based on also the time sharing. It's calculated that both parents are going to be involved. So it takes some relief from one parent to the other. That's calculated into the child support formula. So if one parent is not seeing, and they're supposed to be, their child support could go up. The court, can modify, has the authority to modify with the proper evidence presented. Can modify.
Okay. So I almost was thinking the opposite. So the former husband is not spending time with the children. He cancels his time on a regular basis. So if that's voluntary on his part, then if I'm understanding you correctly, then his child support, if he's paying, it could go up.
Because so let's say it was based that he was going to have the children 2 nights a week.
Sure.
And every other weekend.
Right.
Or that, okay, and he's not doing that at all.
Right.
Okay, so then he's not doing the overnights that were agreed to and required.
Yes.
So his child support's going to go up. Yeah, because when he's having the children, or when the other party is, that's a relief to the other parent, not providing meals and taking care of the children.
Of course.
It's a financial impact.
Yes.
So that is why the formula takes into account the number of overnights also. Income and the number of overnights that a parent is.
So that's really something to think about. And my next question is, when something like that happens, is there a long time frame to possibly adjust that? Like, let's say, this is happening, habitually for 6 weeks, 8 weeks, 2 months.
You're going to want to be, I'll go back to what I've said in previous shows, is get that calendar, the nice big squares in it that say, and that you can be tracking every day, every weekend. He or she, did not pick up, did not pick up, and you're recording it, and so you have a thing. So if this is happening over, let's say, several months, there's a good basis to go in and say, I need a modification here.
Yes.
Modification.
Okay.
So it can be addressed.
That's really good to know. Another, I didn't know any of this. So much of this is really, really informative. So if I receive an inheritance from my parents, is my wife entitled to half of it?
If the, and is the husband saying, okay, so not necessarily, no. I mean, the quick answer is no, he's
Okay,
not.
okay.
As long as it is not commingled, meaning do not put it into a co-bank account, it is not.
Okay, very
It's
good.
not. It's
Wow,
not.
we're
I
almost
know,
done with our
we're
show.
almost done, and I wanted to talk about,
know.
you know, I guess we're going to have to save some of this.
Yeah, we
Just
will.
remind people, because I always like to talk a little bit about life, about what's going on. Get your hurricane kit in place. It is
boy.
hurricane season.
Yes.
Be stocking up now, and they have to buy one, get one freeze. I like peanut butter. The pears, you know, you get your canned goods, your first aid kit, water, you know. So when you're doing your shopping, get a bottle of water. Here are your cases of water, so you're stocking up for the hurricane kit. We have to be ready in Florida. We live in Florida. A hurricane
boy.
can happen at any time.
And you and I have lived through a lot of craziness down
Yes,
here,
we
haven't
have.
we? So,
Yes,
and I
we
know
have.
many of you have. That's really a good way to close the show,
So-
is, you know, and that's something that I love that you do, is giving some tips on safety and all that. So thank you for joining us today. You're watching Life and Law with Debora Diaz, family law attorney. And if you ever want to be a sponsor, feel free to get a hold of Deborah. Thanks for being with us. We'll see you next week.
Thank you so much for watching.